I want to thank Mark for pointing out that the documents are up, and in him pointing out that the documents are up, I have come to realize that I was wrong. So, for everybody out there who thinks that I am incapable of saying when I'm wrong, I'm wrong. I was under the impression that this was all related to the civil case, to the 1983 lawsuit entirely, that it was the defendants in the civil case who were attempting to get access to the Google records of the plaintiffs. But it's not. It is a response to a warrant, search warrant, issued in the criminal investigation. So they have issued a warrant. I believe, I'm not entirely sure who this is, but I'm believing it's going to have something to do with either Bow or Mr. Freeman, Mr. Springer. So this is going to be Bow or Freeman. This one is Ohio Guardian 2. This one is the opposite, I believe, of either Bow or Springer. And then this is Buckeye in the Sky News. I don't know why they're targeting these. I have heard that Earl was noticed, and I thought that Common Joe was noticed. And that might be. I'm just guessing. I don't know how Earl or Common Joe would be really involved in these, but maybe. So I am, yeah, and there are just the three exhibits attached. There's the incident report, which we've seen before, and then there is more incident reports, I believe. So this, now I don't think this is terribly well done. First, you may notice that they're seeking an order temporarily enjoining the defendants from searching the electronic devices. This is not an order enjoining them from. Well, then they talk about the warrant for Google's records. So I don't think it was terribly well written. You can obviously read it for yourself. I'm not going to go on a full breakdown. I don't think it was terribly well written. My gut instinct is that it's not going to work, and I'm going to tell you why it's not going to work. Why I believe it's not going to work. Hashtag, I am not an expert on this, but I'm going to use my legal analysis for you, and you could tell me where I'm wrong. I don't think it's going to work because he is asking a federal court to issue a temporary restraining order based on a novel interpretation of a state law. And believe it or not, I know we're all kind of trained to believe that federal courts trump state courts, but when it comes to interpreting state law, federal courts defer to state courts. So even when the Supreme Court is looking at like a fighting word statute, a breach of the peace statute, they will defer to the analysis of the state court where the state court has interpreted that breach of the peace statute. But then the Supreme Court gets to ultimately determine whether or not that statute, as it's been interpreted by the state, whether or not it's in violation of the federal Constitution. So I hope that makes sense to you. This state statute is being used in something of a novel way, and I'm saying it's being used in something of a novel way, relying on the analysis I have seen from Mr. Prickett, who is a Texas attorney who was kind enough to offer some insight on this particular statute. I could not find anything in my research where this statute has been used in the way that Leon Valley is attempting to use it. That doesn't mean they can't, but it does mean that it's something that the federal court may not wish to get involved in. In order for them to issue the temporary restraining order, they have to show certain things. There's 4 basic things that they have to show, and they list them. They have to show that they're going to win, that they're most likely going to prevail on the merits. Somewhere in here, they go over it. All right, so the four prerequisites are substantial likelihood of prevailing on the merits. That's going to be really hard for the federal court to determine because this is a novel application of a state law. Number two, irreparable injury. I don't think that there's going to be irreparable injury if the federal court does not grant, or if it fails to grant the temporary restraining order. What's going to happen is the state will get the information. The state still has a duty not to just leak that information all over the place. If they do leak it, then they may face more lawsuits that could cause damage. Like if they leak out the defendant's credit card information, well, the defendants in the police investigation, the plaintiffs in the civil investigation, if they release their credit card information, obviously that would be, a violation. The public interest to be served by granting the preliminary injunction. I don't believe there is a huge public interest to be served by granting the injunction against it. And the harm, I don't think there's going to be huge harm. They go out of their way to try to make it sound it's a blatantly false arrest. Oh, well, if you say it's a blatantly false arrest, failure to identify, etc. There's all sorts of wonderful arguments they're trying to use. It's not... I understand the intent of this attorney, but it's not terribly convincing. He's trying to say, that it's a search of the cell phone. It's not searching the cell phone. They're asking Google for Google's records. It's not. They're not invading the privacies on a whim. They have a warrant that has been issued based on probable cause. You may personally disagree with it, but it was signed by a judge, and the judge apparently believes that there is probable cause. Jefferson Moore is a judge in the 186th District Court of Bexar, Texas. So you might notice, like, the public interest, there could be no bigger public interest than for the public to know their constitutional rights will not be shredded. They followed the due process procedures. They went for the Google records. I mean, not for taking the phones. These are two separate issues, so I need you guys to bifurcate this in your minds. I know he's trying to mix them together. I know this attorney is, because I believe that this attorney realizes that he has a very weak case for blocking the warrant into the Google records. So due process was followed. The police got warrants for this information from Google. That's exactly what the Constitution requires. That's exactly what the Fourth Amendment requires. Warrants will issue on probable cause. There you go. Judge said there's probable cause. And he doesn't even highlight D. He just says any harm possibly resulting to other parties in the proceeding. And the plaintiffs challenge the defendant to say any harm the defendants will suffer if they're not permitted to unlawfully. See, again, he's trying to mix up cell phones. He's just making a legal analysis or a legal conclusion that is unlawful. It doesn't really work that way. But yeah, links will be up there. I was wrong. It is not a subpoena. It is a warrant. I don't think the plaintiffs in the civil case are going to win. Thank you, Mark, for bringing it to my attention. And I was wrong. Somebody needs to cut that, paste it all over the place. Just to let everybody know that I am willing to admit it when I'm wrong, despite the prevailing wisdom. Thanks for watching. Have a great day.